I will point out that there's been more than 100 state laws that have changed, which means that we have more than one bite at the apple, right? We have many states who have changed more than one law. There are 2 federal laws that Brian will talk more about in a little bit that incentivize states to remove young people from their adult facilities. And as a result, we have 150,000 to 200,000 fewer children every single year that lose their childhood status, and that is something that we should all be celebrating. So with that, I'm going to turn it over to you, Brian, to talk about more in depth about these trends.
Thank you, Marcy, and welcome everybody. As Marcy mentioned, we've been doing this work since 2005, and this is our final trends report. And as with every report, we look at the last 3 years or so. This report covers 2018, 2019, and 2020. Even though a lot of state legislative sessions were somewhat truncated this year, there still was quite a bit accomplished in a positive way for youth justice. And we, as in previous reports, we're looking at 4 sort of main trends. The first one is of course, raise the age. This is changing laws in states where all 17-year-olds or all 16 and 17-year-olds are automatically charged as adults just because of their age. And we've seen 13 states change these laws since we started back in 2005. In the last 3-year period, you can see on the map here, we had 2 states in blue that passed laws, Missouri in 2018 and Michigan in 2019, and 4 more states in brown that fully implemented raise the age laws that they had passed during a previous period. And then we had 2 states, the ones in orange, Vermont and Colorado. Vermont raised its age to include 18 and 19-year-olds in the juvenile system. The 18-year-olds has gone into effect this year. The 19-year-olds will go into effect in 2022. Colorado is studying whether to do something similar to what Vermont did. I guess the one sort of takeaway from this is that with the states that implemented raise the age, we've started to get some data, particularly from New York, where the 16-year-olds became part of the juvenile system in 2018. So we have enough time to get some data. We've seen a big drop in arrests of 16-year-olds, and that fits a familiar pattern we've seen with raise the age states, where as children are seen as children rather than adults, arrests suddenly start to drop. We call it the disappearing effect. And we expect similar kinds of results in other raise the age states. Michigan's raise the age law will go into effect in October of next year. Missouri's will go into effect January 1st of 2021, although there is some dispute about whether enough money has been appropriated. There's a blue ribbon panel that has not met enough to resolve that dispute. We're hoping that after the election, that panel will step in and make sure that that dispute is resolved and gets implemented on time. But it's not 100% clear what's going to happen in Missouri come January. That's the case with the raise the age trend. As you see on the slide here, this is absolutely the #1 driver of children into the adult system, and the #1 taker of children out of the adult system once you raise the age. In 2015, there were about 76,000 kids charged as adults every year. Since we've seen these 4 states implement raise the age, that number is probably half what it was, and it's going to drop further with Michigan and Missouri. Now we have only 3 states left to raise the age: Georgia, Texas, Wisconsin. Georgia did have a bill this year that made it out of a House committee, but COVID obviously came to the front, and a lot of states were not able to accomplish what they might have accomplished in terms of any kind of legislation or reforms. So that's raise the age. Go to the next slide. I don't think I have control. Thanks. So the next trend that we've looked at over the years has been jail and prison removal. This is where we try to get children out of adult jails pre-trial, and we try to get children out of prisons even if they're sentenced as adults. And this map represents the changes we've seen during the entire time that we've been in business. Green is for laws that are passed to get children out of prisons. Brown for getting children out of jails. And the sort of burnt orange, as we say in Texas, is the color for the 3 states that have done both. As Marcy mentioned, there's 2 federal laws that are key facilitators of what we've seen as major drops in children being jailed or imprisoned with adults. That first one is the Prison Rape Elimination Act, passed in 2003, and a youthful inmate standard that was part of that act that was implemented in 2012 that required children to be sight and sound separated from adults if they were to be locked up with them. This has led a lot of facilities in a lot of states to try to get children out of adult facilities. In 2018, in December, President Trump signed the Juvenile Justice Reform Act, which included a reauthorization of the Juvenile Justice Delinquency Prevention Act. And in this new version, children who are charged as adults are required to be kept out of adult jails, with some exceptions that require judges to consider a whole lot of factors. Right now, we think there are about 16 states that are in compliance with this JJDPA requirement, plus Washington, D.C., so there's a lot of work yet to be done on that score, but we have seen a tremendous drop in the number of children charged as adults, also the number of children jailed with adults, as you can see on the left side of the slide here. During the last 3 years, 3 states brought their laws into compliance with JJDPA: Delaware, North Carolina, and Washington. And Oregon passed a law to initiate data collection to ensure that they are in compliance with JJDPA. And Nevada initiated a study with which we've been participating to look at their whole juvenile detention system, including the question of children charged as adults. New York, as a result of their Raise the Age law, there was kind of a bug in it in which 16 and 17-year-olds sentenced as adults, known as adolescent offenders, were being held in a adult side operated facilities. The governor's budget this year took the adult side away, took that authority away from the adult side. So those 16 and 17-year-olds, as of October 1st, just 3 weeks ago, children who are sentenced as adults in New York are under the jurisdiction of the Office of Children and Family Services, the juvenile side. So that was a prison removal for New York. North Dakota did so as well, affirming what they already had in place, that they do not lock children up with adults in prison. Other states, Tennessee, Utah, and Virginia, passed restrictions on children being jailed with adults, but did not bring their states into compliance with JJDPA. So that's the jail and prison removal. So the third factor we look at is judicial and reverse waiver. These are transfer, and when we say waiver, we mean back to the juvenile system. Transfer, we mean into the adult system. Other states might have it differently. These are mechanisms in which a judge has full discretion to decide. So judicial transfer, the judge decides whether a child goes to the adult system or not. And reverse waiver, a judge decides whether or not a child goes back to the juvenile system. It's a very common, the most commonly present transfer mechanism. 45 states have it. It also is unfortunately a mechanism in which there are growing racial disparities. In 2005, the percentage of Black children transferred to adult court by a judge was 39%. In 2018, it was 51.7%. At the same time, white children transferred by a judge were 45% in 2005 and 32% in 2018. So there's been a significant increase in racial disparities in judicial transfer. We also see on this graph here that there's been a sort of slow but steady increase in the use of judicial transfer for person offenses, which are more likely to be violent offenses. This is a result of children charged with person offenses no longer being automatically transferred. So that's a good thing. But we do see this trend slowly going up in which more children charged with person offenses are judicially waived. This past 3 years in our trends report, there hasn't been a lot of movement on this particular form of transfer. The big deal is that California in 2018 raised the age of transfer to 16, so that children under 16 cannot be transferred to the adult system in California at all. Tennessee also did some tweaks to their judicial transfer law to restrict some offenses and some ages, which was good. And a couple of states have expanded their reverse waiver, California and Vermont. But that's judicial transfer. And so this is the what we call the sleeper campaign. Automatic transfer is sort of the growing mechanism of transfer. As we've seen, raise the age laws pass. We're seeing more and more transfers concentrated among children charged with violent offenses. And that's where automatic transfer mechanisms are most often used, even though, as you see here, you might see on the next slide, there's no correlation between violent offenses and automatic transfer usage. There are 9 states you see in the green here that have totally repealed an automatic transfer mechanism. You see there on the East Coast, West Coast, South, Midwest. So it's all over, it's all in a lot of places. A lot of other states have, of course, narrowed their transfer provisions, automatic transfer provisions. The laws can vary widely. In Massachusetts and New Mexico, for example, it's only used for murder. In Maryland, there are 33 offenses for which children are automatically excluded. There's are huge racial disparities in the use of automatic transfer. Can you go to the next slide? So these are the states that use automatic transfer the most. As you see, again, geographically kind of all over the place. New Jersey and Florida have passed reforms. Those numbers should probably go down. In addition, Pennsylvania and Philadelphia particularly, and Florida have some prosecutors who are shifting their practices. You note here Ohio and Tennessee. Tennessee does not have automatic waiver, but they have judicial waiver that is used very extensively in Shelby County, where Memphis is. In Ohio, the prosecutors in Cuyahoga County account for almost half of all the statutory exclusions. So they're charging children with sort of the maximum level offenses, a lot more than the rest of the state. Every state has, as I mentioned, terrible racial disparities. To the extent that we know, there are only 18 states that collect and disaggregate data by race on their automatic transfers. So we know, for example, in Ohio, over 81% of children automatically transferred are Black. In Maryland, it's almost 80%. Indiana, 66%, Florida, 65%, Arizona, 82% of automatic transfers are children of color. So huge racial disparities in this particular form of transfer. We did see a lot of progress on this in the last 3 years. Florida and Oregon repealed their statutory exclusion statutes outright. Florida, of course, still has a prosecutor direct file, so there will still be a lot of automatic transfers in Florida, but it might drop by a couple hundred. Rhode Island repealed its mandatory transfer law, and Indiana passed a very important data gathering bill that disaggregates data by race, that tracks outcomes that we believe will demonstrate that the pointlessness of this particular kind of transfer, that the lack of correlation between violent crime, and of course the huge racial disparities that exist. Other states restricted their automatic transfer bill, our laws, Arizona, Delaware, Utah, and Washington, and even Vermont restricted their statutory exclusion law for children under, or for youth under the age of 21. So again, to go along with their raise the age law. Virginia this year raised the age of their prosecutorial direct file to 16. So children under 16 cannot be directly charged as adults by a prosecutor in Virginia anymore. This was very significant. Virginia passed a lot of bills this year before COVID hit. They have a very short session very early in the year. They also eliminated mandatory minimums for children sentenced as adults or charged as adults. And they required all children sentenced as adults to have parole eligibility after 20 years. So Virginia made some huge progress. And we do believe, if not for COVID, if not for all the other interruptions this year, for example, Kentucky would have probably repealed their automatic transfer statute. Georgia might have passed their raise the age bill. So there was good progress this year. The report documents it well, but there could have been more under different circumstances. And with that, I will turn things back over to, I guess, Marcy.
Thanks, Brian. So I want to turn this conversation over to one of our great state partners in Michigan. Michigan had a very long fight to raise the age, and Jason Smith is here with us to talk about how they did that and how they were able to manage to get hundreds of counties on the same page and get this law passed. So Jason, I'll turn it over to you.
Thank you, Marcy, and thank you, Brian, as well. The Campaign for Youth Justice was so helpful, instrumental really to the success of the Raise the Age campaign in Michigan. So all the resources, all the information that they were able to bring to the table really helped us as advocates see some of the same successes that other states were able to achieve. So we really appreciate that. And now when I'm talking about our strategies and how things came to be, I'll pepper in some more things for the campaign in that. So as Darcy mentioned, it was a long time coming here in Michigan. From the point when my organization, Michigan Center for Youth Justice, which served as the coordinating org for the Raise the Age coalition, of a coalition of advocates that participate in the Raise the Age campaign. I'm always hesitant to say that because I don't ever want to diminish all the great work that grassroots organizers and other folks did around the state. I mean, there were some really passionate people that participated in this campaign that may not have been a part of the core campaign group that participated in calls, but really helped out on this campaign, and I'm really grateful for that. But anyways, from the point that we began this campaign, really launching the public education and awareness campaign on this issue of youth in the adult system in Michigan and highlighting Raise the Age as a significant issue in our state. We started with a report, Youth Behind Bars, that highlighted that, the youth in the adult system and the consequences of bringing them there, and the issue of 17-year-olds automatically being prosecuted as adults. From that point to the point of actually getting the legislation signed into law last October, almost a year ago now, in 2019, was about 5 years. And so at the beginning, we were one of 10 states. And so we as advocates, we really had the benefit of seeing other states pass legislation, actually have their law take effect, implement it, and then see some of the outcomes of it. So we were able to share with stakeholders here in Michigan, be it juvenile court professionals, state lawmakers, county commissioners, et cetera, some of that information, again, shared by the Campaign for Youth Justice, but to help knock down some of the challenges that we knew we were going to face, because this issue was similar to what other people saw in other states. So being able to argue that cost estimates were usually overblown, and the actual cost of implementing Raise the Age was nowhere near what a lot of the cost estimates originally showed. That after Raise the Age took effect in other states, a lot of juvenile court caseloads continued to fall, and arrests continued to fall as well, including arrests for young people who were older than the JJ system, so 18 to 21-year-olds, you can say, showing that there is some benefit to serving older youth in the JJ system that's more age and developmentally appropriate for them. So we really benefited from being one of the last states in that regard, I guess. It's not a benefit for the kids, of course. But we were able to also bring in advocates and JJ stakeholders from other states like Illinois and Connecticut. I remember folks from those two states came in multiple times to educate lawmakers and JJ stakeholders about what they did to make sure that their reform was successful and that the sky hadn't fallen after the legislation had actually passed. So that was huge. That it also brought, I feel like, a sense of inevitability that because everyone saw in real time other states passing legislation, there was, and we were one of the last 4, I believe, when we passed ours, that it was going to happen. It was only a matter of time. And I think that some of the people who agreed philosophically but had concerns around cost or implementation, that sense of inevitability brought them to the table in a way where they actually contributed to finding out or figuring out solutions to making sure that the law could pass and be implemented successfully and not just obstruct with their opposition. We learned early on that it was important to build a huge coalition. Again, that's a lesson taken from other states and other campaigns as well, legislative campaigns. But again, we had strong partners like the ACLU, some progressive advocacy groups here from the beginning who contributed mightily to the campaign from the outset. But over time, we started to expand to include members of faith-based communities, business groups like local chambers of commerce, more conservative advocacy groups, libertarian think tank groups, both here based in Michigan and nationally, that were able to bring in more supporters and tailor messaging around Raise the Age, really lift up that moral argument, that economic argument in ways that other folks could understand them in a way that we probably couldn't message it ourselves, or just being the messenger, they weren't receiving the same way. And towards the end, when it really seemed like it was likely that Raise the Age passed, we just saw huge support, more and more coming from state associations like the Parent Teachers Association here in Michigan, medical groups, public health groups, come on to support. And then national groups like the NFL Players Coalition, the group that the NFL organized to focus on criminal justice reform, did op-eds for us. They sent a letter to the governor encouraging her to sign the legislation once it finally reached her desk. So we understood the importance of having a big umbrella. And I am really proud that even though we had a very diverse group of advocates and supporters taking part in this campaign who may not agree on a lot of things, everyone pulled together and really embraced being a part of the Raise the Age campaign coalition, understood that the Raise the Age newsletter and our webpage and any kind of messaging that came out didn't just speak for us, the Michigan Center for Youth Justice, but all of the coalition members. And so it was cool to see a diverse group of stakeholders be on the same page about a particular policy. So another strategy that we took to ensure that the campaign would be successful was to give space to stakeholders to voice their support for Raise the Age, even if it may come in conflict with their professional association. So again, from the beginning, it was clear for many people that they philosophically and morally agreed that Raise the Age was the right thing to do and that it should happen. Some of their professional associations, mostly on the counties, because Michigan's juvenile justice system is decentralized, it's county controlled, local control and local jurisdictions are very strong in matters related to juvenile justice. That cost concern component that, played a role in every Raise the Age campaign nationally really took hold for counties. Even with that, there were court administrators, there were judges, county commissioners, et cetera, that were really passionate about this and wanted a way to contribute to making raise the age a reality here in Michigan. So we worked with folks to produce op-eds showing that it is not a blanket opposition to this policy. One of the suggestions that actually came from Brian in the Campaign for Youth Justice, based on its success in another state, I think it was North Carolina, was
Oh, Jason, we seem to have lost you for a second. You've got us on a cliffhanger. Oh, we might need you to. We might need Jason to call back in. I'm going to leave him to tell his story because it's really important. It is really, really important that he tell that part of the story, but I'm going to wait till he signs back in, and I'm going to, in the interest of time, move on to two of our panelists who are joining us from California. And I have to say that California has just really been champions in this fight for young people. They have a series of laws and an incredible ground game that really helped get them to where they are now. Oscar, if I can turn this over to you to tell a little bit about your story and how you got involved in the policy work in California. And thanks for joining us so early this morning.
No problem. Thank you, Marcy, for that wonderful introduction, and thank you for having me. Yeah, well, my story started in 2017 while I was in DJJ in California's the Division of Juvenile Justice. I was sitting in a group with the ARC, the Anti-Recidivism Coalition, and I got approached by one of my mentors now. His name is Ken Mendoza, and he began telling me about all these changes that are soon to occur in California. How 14 and 15-year-olds were advocating for they don't be tried as adults. And mind you, I was already incarcerated for about 4 years. I was already incarcerated from the age of 14, and I was already, at this age, I was 18 and a half. So I already met a lot of my friends while being incarcerated that got sentenced to life, 25 to life, 80 to life, 100 years to life, 250 years to life. And these were little kids, 14, 15-year-olds, the same age as me. But they got tried as adults. They didn't get the opportunity that I did, and I got tried as a juvenile. So while sitting here in this room with, I didn't get disconnected, correct?
No, you didn't. I'm sorry.
Oh, okay.
I did something, and I don't know what I did.
That's okay, Marcy. I just wanted to make sure I didn't get disconnected. Well, moving forward, I began hearing up to Ken. He began expressing to me about how our stories aren't heard, how we can make change. And while being incarcerated, I was already in my first year of college. I obtained my high school diploma, first in my family. Nobody's ever got their high school diploma. I was one of the first ones. I started attending college, and I began educating myself. And I was soon to get released. I was 6 months to getting released, and I reached out to my mentor. I was like, hey, how can I get involved? He's like, you know what? Just come out to our office, and you can start off on policy training and start off like that. So what I did is, as soon as I got released, I went to ARC. And my passion, my drive was not for me because I'm already home. I'm home. I came home at 19 years old. So when I went to college, basically I was telling all the youth, hey, I just had a gap year. You know, I didn't tell nobody I was incarcerated. You know, that's how it went. So my passion, my drive for this work was mostly all the kids and all the individuals that I left behind that are still incarcerated right now, still having these long sentences. So I began attending these policy trainings and began learning, educating myself about different laws and how in California in 1990s, how they said that kids were fully developed at the age of 12, 13, but it's scientifically proven that we don't develop until the age of 25. So that enraged me. That made me mad that basically people were fed lies, and that's why kids were getting tried as adults. So we began advocating for SB 1391 in 2008, and that bill is basically that won't allow the district attorney to direct file 14 and 15-year-olds. So now it's up to the judge's discretion of if the kid can stay in juvenile court. So I began going back to Sacramento, flying now, meeting wonderful people that are on this call currently, and we began advocating and letting them know of our stories and how kids deserve a second chance at life, how put yourself in your shoes. If you're 14, your 15-year-old kid, your cousin, your 14 and 15-year-old son, you know, they do a mistake and that lands them for the rest of the jail in life. And we began pulling out how statistically it's unfair that it's just because we don't really have money to pay for our lawyers. We don't have the means necessary to be able to like get compared to somebody with financial means. So we began advocating for this, and at the same time I was going to school. I was full-time employed. I was working 2 jobs as a caregiver, helping people Alzheimer's and dementia, and ultimately I was just going back advocating and doing that work, and ultimately it passed. And that was the best feeling, that like just seeing it pass, getting passed, and being a part of it was something I was very proud to be part of. Currently, I am a site supervisor. I just applied. I just got hired just 2 days ago. I started off a year as a guidance counselor for kids coming home from DJJ. So now I'm helping individuals that are in my same shoes that are coming home to show them that there's people that care, that change is possible, and don't give up. That, you know, like there's more to life than we're accustomed to. And now I have 4 beneficiaries. I don't call them my clients. I don't call them, I consider them my 4 friends, and I help them seek employment. Sometimes they call me, hey, I'm going through some depression. And I'm there for them because I know how it is for somebody who was there for me. For example, Elizabeth, you know, she helped me out from the start. She gave me my first laptop for college. And I remember all that. So now my way is just to pay for it. And I tell all these guys when I help them out get jobs and stuff, I tell them, I don't expect nothing. I don't expect money. I don't expect nothing. I just want you to pay for it. So I get very emotional because like I'm like, damn, like I came so far, you know, and I'm still gonna go. I'm still gonna push. And yeah, like Marcy said, California is a big state, and we're doing this. I can only imagine all 50 states pass this law, and how many 14 and 15-year-olds will be sitting here in front of you guys, telling you guys, like, I'm a counselor, I'm a supervisor, I'm somebody, I'm not just this incarcerated individual. It'll be pretty cool. So, thank you for having me, and I really appreciate it. That's a short skit of my story. And just, you know, to be continued.
So I think Oscar deserves a round of applause for that recent promotion and for the many lives we know you will continue to touch, and the fact that you made the decision with many others in California to change the law and say no more really has been monumental in changing the narrative in California. So thank you for jumping on with us today. I really appreciate you. And you referenced Elizabeth Calvin. I'm gonna turn the mic over to Elizabeth because I think she has such a wonderful wealth of knowledge of the many, many steps that got California to 1391 and to raising that floor of transfer to 16 years old, which is really just amazing. So Elizabeth, can I thank Oscar and turn it over to you, and you can give everyone the history and show evidence that it's not just one time that we get to pass these laws, that they can build on each other.
Yeah, and thank you, Oscar. And you know, of course, you made me start crying before I start speaking, so thanks a lot for that. But it's beautiful to see you, and I think I'll start by saying that you know, Oscar is an incredible person and also has a lot of humility, and really he played a crucial role with his testimony. And you know, he's the kind of person that we would walk into a meeting with legislators and we'd do the meeting, and then we'd come out in the hall and he basically would be like, okay, how can I do that better the next time? And we would talk about it, and then he'd go in and he'd, you know, up his game each time, and just very, very strategic, very smart, incredible partner in this work. So, and I'll just say also with reference to that, and not just Oscar, but literally hundreds and hundreds and hundreds, perhaps thousands of other former incarcerated people, their families, people who have direct experience of the system, that is their testimony, their leadership, their involvement at every aspect of the work that we've been doing is why we've been able to pass the laws we've been able to pass. I mean, of course, there's about 1,000 reasons, some of them having to do with luck, that have allowed us to change some of the laws here. But if I was asked, choose one thing that really changed things, that really changed the direction, it was the leadership of formerly incarcerated people. And that's what changed the direction that we were going. So I think one way to look at what's happened in California is in 2008, we had about 1,200 youth who were prosecuted as adults in that year. And in 2019, we had 64. And so obviously there's a lot of other things happening. Fewer youth are being prosecuted for crimes. There's crime is dramatically dropped, etc. But there's changes in attitudes, and there's also changes in laws that have happened during that time. When I first started working in California in 2006, really what I wanted to work on was ending transfer. But what became clear is that there was no way to go at that head on here for a lot of reasons that are similar in other states, and some things that are different that have to do with when laws have to be passed by a 2/3 majority here. So we came at it kind of from a different perspective. And we worked on the issue of life without parole, and then we worked on the issue of really extreme sentences for people under the age of 18, and then popped it up to working on extreme sentences and ending extreme sentences for people under 22, and then most recently popped that up to age 26. So this idea of working on kind of the worst things that can happen to kids when they are tried as adults and trying to peel that back, both to actually create relief for the literally thousands and thousands of young people who were sitting, at that time there were more than 6,500 youth who had been under the age of 18 who are currently in California prisons, serving sentences sometimes in the hundreds of years. And even if it was only a 15 to life sentence, the parole rate was hovering around 6%. So it really was a sentence that would never get you out. So we were able to pass, finally, after many, many years, a law in 2012 that allowed for resentencing and life without parole sentences, and then passed in 2013 a law that allowed people under the age of 18 who had lengthy sentences in adult prison to have an earlier parole and a thumb on the scale because they were younger. So they were required, the decision makers, the parole board is required to consider their youthfulness. After that, trying to kind of circle back and actually work on the issue of transfer, we tried to introduce several different bills that would reduce transfer, and each of them got shot down because of those kind of crazy California restrictions that I mentioned that have to do with 2/3 votes. And we finally came up with one that tweaked, and I mean really just tweaked, not radically reformed, but tweaked, so that we could skirt the edge of that, is it a 2/3 vote? Tweaked the criteria that judges use in order to decide whether to transfer a youth to the adult system. Now, at the time, I wondered whether it was even worth it, because at that point, only 20% of cases were decided by judges, and we were changing the criteria that judges use. And meanwhile, it was a black hole in terms of how decisions were made for 80% of those cases, because they were either automatic or they were discretionary on the part of the prosecution. And I think everybody knows those decisions happen within 48 hours. They happen behind closed doors. There are no guidelines. They dramatically differ from county to county, and they are horribly racially biased in terms of who gets, the decisions are racially biased in terms of who gets filed on and sent to the adult system. So we were able to go, we decided to go ahead and change that criteria. And I bring this up because even though it was on that narrow group of individuals, what it did was allow us to go door to door, from legislator to legislator, in the public, in the news, and talk about the issue of transfer, and talk about how horrible it is for a young person to be transferred to the adult system. And when we did pass that law, it changed what was happening inside the courtroom. And judges stepped forward saying, we're so grateful that we now have these tools that we can use that slightly change how we consider what happens. But also during that time period, we kind of hit a wall in terms of realizing that we were just never, again, because of the crazy California laws, never going to be able to pass something in the legislature that really transformed the transfer process. And so we ultimately, as Oscar alluded to, in 2015 began working on a ballot measure that was put on the ballot in 2016 and passed overwhelmingly. And it completely eliminated prosecutorial discretion. It completely eliminated automatic transfer and made it so that every single case had to be decided by a judge. And right about then, we were pretty happy that we had changed the fitness criteria because then judges were using that criteria. And that's when you began to see just a pretty dramatic drop. The following year, a bill was introduced to completely eliminate the prosecution as adults of youth under the age of 16. And we were able to pass that as well. Now, I would have liked to have included that in the ballot measure, but we were unable to do that basically for political reasons. So we came back the following year and were able to go forward with that. And now I just want to talk a minute about something that everybody here knows, but I'm just going to say it out loud anyway. And that is, as depressing as it sounds, passing the laws is the easy part, and making sure that they are implemented correctly, making sure that they're defended from challenges is the most critical part. And so as is stated in the materials, 1391 was immediately under attack, immediately before it actually was enacted. It was under attack by district attorneys in the courts, alleging, again, a very narrow California issue that had to do with the process of passing it. And that is currently in the California Supreme Court and will be heard probably early next year. I don't want to jinx it, but I'm feeling, relatively optimistic about our chances of winning there. I do want to point out that the challenge has nothing directly to do with trying youth under 16 as adults. It's all about like this what most people would consider technical. It is a constitutional issue, but we have a lot of stuff in our Constitution here, a technical issue. So I bring that up because, of course, district attorneys are going to use whatever they can to undermine these kinds of advances. And they went all out. And so I just want to say that I think there were close to 30 counties. We have 58 counties, 30 counties in which this kind of stock brief was filed and they were challenged. And so what we had to do on the ground is put together a team of expert attorneys who are experts on writs, experts on transfer, experts on appellate issues. And we basically reached out to every single public defender, and that was about 65 cases in which this was being challenged, and offered them a consultation with this panel of experts, gave them sample briefs, reviewed their briefs, helped them with their arguments. As they went up through the appellate process, we helped them with that as well. And I think that's one reason. Last count, I think we had 5 appellate courts find it constitutional and 1 found it unconstitutional, and that's how we ended up in the California Supreme Court. I bring up that kind of level of detail because of, again, the importance of defending the wins. And we also have been doing some kind of communications, press work related to that. So I'm going to go ahead and Oh, actually, God, let me tell you one other thing that we just did this year that is relevant to all of this, and that is less than a month ago, just a few weeks ago, it's been a bit of a whirlwind. The governor signed a budget trailer bill, which is a law now, closing DJJ, closing our youth prisons. So this is a huge, huge effort. And I want to say that we have people in California who've been working on this literally for decades. And there were a number of things that have come together that made it possible. And part of it is COVID and the economic crisis and a governor deciding, hey, maybe this is a way to save some money. Turns out that's not going to really be a way to save money, but it is what kind of propelled things forward this year. Behind the scenes and kind of the backstory of this is that in California, it would have been very easy for our various youth justice communities, youth justice advocates, activists to be kind of at war with each other, with some people saying, yes, we have to close DJJ at all costs, and other people saying, whoa, whoa, we need to be careful how we close this, because if we don't close it correctly, we're going to start increasing the number of youth that go to the adult system. Because of course, as horrible as youth prisons are, they're about 10,000 times better than being sent to an adult prison. And in California, as we've seen that drop in terms of number of transfer cases, we've seen an increase in the number of youth going to our juvenile prisons. So by closing them, some of our community-based partners came up with the great phrase, close DJJ the right way. And so we have to, we are still working on that. We've got a lot of layers. I'd be happy to talk with, about what we're trying to do to protect that. But it is something that we're pretty unified behind across the state as far as activists and advocates and the like. So I'm hopeful that we'll be able to pull this off in the next few years. And I'll go ahead and stop there.
Thank you so much, Elizabeth and Oscar. I think you kind of see from both of them how unflappable they are in the face of difficulty. And Elizabeth, I appreciate you bringing up the implementation, the importance of implementation, because the Campaign for Youth Justice has seen a lot of implementation get challenged. And again, when you build a strong coalition, when you bring legislators along with you, it does get a little bit easier to implement in a way that is authentic and carries the spirit of the law as well as the letter of the law. So thank you guys for always standing behind that spirit. And I do have to tell one funny story about Elizabeth with that fitness. She was the advocates were a little bit sad because they're like, oh, we thought we'd get so much more, but then that little fix really changed the narrative and gave judges such a tremendous tool when some of those other laws came. So celebrate every step of the way, even if it isn't perfect and what you wanted, because it really does make a difference. So I'm gonna turn it over to Brett, who's with us from Utah, hot off the press, with a pretty significant win there that DJJ was instrumental in fighting for. And then after that, Jason, we'll go back to hear about you with the counties. So Brett, welcome.
Oh, good to be here. Good to see you guys. I love how Elizabeth mentioned the luck element in some of these policy efforts, and I can speak a little to that, how it can go both ways. And I also love too, I always want to be grounded in, I'm honored to be on this panel, honored to hear your story, Oscar. That was really wonderful, and helping me and helping all of us marry narrative to policy. Because I can just get too into the weeds on the actual specifics and remember and forget why we're doing it. So thank you. So yeah, last year we had a pretty active session and some pretty big lifts. We set a bottom for juvenile jurisdiction so that kids under 12 could not be brought into the formal system. So that was going, and then we ended up doing a really expansive kind of follow-on to our juvenile reform bill that was passed in 2017. And specifically, we didn't have a huge population of kids getting transferred. We would average around 5 to maybe 10 per year. being transferred to the adult system. But all of a sudden, we started seeing this real increase in the last couple of years, and it was specifically because there wasn't there was kind of an any felony provision is what the law looked like. It was any felony down to 14 years old, and with some findings. Then you had kind of the serious youth offender type mechanism where less findings burden on the individual, not on the state, to retain juvenile jurisdiction for those aggravated offenses. And then we had direct file provisions. And so what we originally set out to do was part of our original kind of legislative package, it was eliminating direct file completely, and making where transfer, the main area we really wanted to focus on was, if we're going to have transfer, it's got to be limited to only these aggravated offenses. This is where the luck and timing part comes into play. I honestly think, and Marcy knows, she was getting some play-by-play during our legislative session. I think we had the right coalition that we would have been able to take direct file completely off the books in Utah, but it ended up, the legislative council, by the time the bill was drafted, it was just like this timing. And so we got so late in the session that we started to have to make, some compromises, because we knew it came out so late into our legislative session that we couldn't have any opposition, any organized opposition. And so ultimately what the bill kind of transitioned into, and it was House Bill 384. So it eliminated any transfer for 14 and 15-year-olds except for murder, ag murder. For 16 and 17-year-olds, it eliminated the any felony provision. It just created that, so it's only for aggravated offenses, and it put the burden back on the state. So it kind of significantly shrunk that doorway. The concession we had to make was on the direct file for murder and ag murder for 16 and 17-year-olds. That was one that we had a lot of prosecution pushback. There's still, the argument, I saw someone in the question is, what would a prosecutor argue? And it's they don't want, the argument is that judicial discretion. So you have a 16-year-old involved in a homicide. What if a judge decides to keep them in juvenile jurisdiction? And yeah, we're like, so what? What if, right? But that's the argument. I can tell you that's the argument. I don't agree with the argument. The other provision we put into place is we really wanted to, make the doorway to the adult court very, very narrow, which we've done that. Then we also wanted to kind of create an incentive to try to keep kids in juvenile jurisdiction, even on those cases that might qualify. So we created an extended jurisdiction provision. So a youth could potentially be in JJ care, remain in juvenile jurisdiction up to 25. So we were able to get that into place as well. I really think that, there's been some consistent themes when you're talking about these big kind of policy lifts. It is about, I think first, if you don't have that kind of philosophical grounding, if you don't have, and you're not going to have everyone on board, that's understandable. But in general, in Utah, where we can have the common themes, we actually are getting a lot of consensus on adolescent brain, the concept of adolescent brain, that we need to treat our kids like kids. Where the conversation goes from there depends on which seats people are sitting in, but trying to come to the table from that grounding position of, here's where we philosophically align. Then it does take, these policy maneuvers and then it goes right into practice. So then how do we implement it? How do we shift our practice? How do we shift our operations? And then I feel like they're just kind of these continually renewing cycles. So, and underlying all that is the partnership. So we actually, with both of those legislative lifts last session, House Bill 384, which is this transfer bill, and also our 12 and under bill, we ended up having our prosecutor, their statewide association, they actually endorsed, both of those bills. Like I said, there was some compromises in there, but we felt like we did have to have that very, very robust partnership and alliance, and a really strong defense voice in all of that, really strong advocacy voice. Obviously, I'm with the agency, so a strong agency presence, and we were able to get those through. I love again, I think what you said, Elizabeth, you set out to end transfer. I hear you, and that's just one of those things that it just haunts me every time I see one of these kids, and you know, whether they're in a JJ setting but they've got this adult record, or you know, the worst scenarios where they are in an adult actual setting. I just think it's horrific, and it's something that we can continue to kind of battle for and find the right sizedness to it. And I do think that first step, I hope, nationally, will be ending direct file. At least, you know, having that element, that evaluation by a judge, is got to be where, you know, we head. So yeah, that's Utah's last year in a real quick nutshell.
Brett, thank you so much. And I do have to say, I really want to thank Brett, because he really, you know, as a DJJ director, really is a voice that people listen to, because he knows these young folks. And not only has he helped to bring along the legislators and tackled this with some of the folks in law enforcement who maybe weren't fully on board, he's actually talked about this in many different places nationally, which I think then gives both courage and permission to his colleagues who also have similar positions, to also take risks like this. I think there's always fear in the unknown, but what we have seen, particularly around the jail and prison removal, is once those young people are in a more age-appropriate setting, and I would argue that once they're there, many people in DJJ think that they would be safely served in the community, is that all of that mystery goes away and they are seen as the children that they are. But that fear that has been perpetrated for 30 years about who these children are is real. And so I appreciate you taking that this conversation nationally. Thanks, Brett. And big applause for Utah. So as you guys can hear, even though Utah and California, they're very different, even though they're both in the western part of the country, and a lot of the reforms around automatic transfer, ending automatic transfer, whether it's direct file or statutory exclusion, or taking away presumptive waivers from judges, really has taken hold in that western part of our country. And there, you know, whether it's Republican governors or Democratic governors, it really has been a bipartisan effort. So I want to point that out. Before we go to questions, Jason, I see you back on. Do you want to finish your conversation about the counties? Because I do think county by county, Michigan does have rural counties, does have urban counties, and I think what you were about to say was really important.
Sure, yeah. Sorry about that. That's the joy of remote work with internet going out. Don't remember exactly where I left off, or the last thing that folks heard.
I think you were about to talk about the county proclamations or resolutions.
Oh, the county resolution. So that was actually a suggestion from Brian in the Campaign for Youth Justice, based on the success of getting county-based resolutions passed in North Carolina in their Raise the Age campaign. And it really was successful here. We started off with the most progressive counties. So Washtenaw County, where the University of Michigan is, and Wayne County, where Detroit is, one of the largest, or the largest county, where we had strong support for this policy. And even then, the county commissioners worked with their prosecutors on the language that they supported. We gave them the language directly from, I think it was Mecklenburg County. Is that the name of that county in North Carolina?
Yep.
Their resolution, and they tweaked it to fit them. They still wanted the cost concerns addressed. We have a part of our constitution that mandates any kind of legislative changes at the state level, that funding be given to the local jurisdictions to implement them. So in addition to just the general cost concerns that comes along with the Raise the Age conversation, counties also, you know, put forward this Headley Amendment, which is the constitutional amendment, as one of the things that had to be addressed, which added an extra layer to this cost conversation we had here. But it was clear that there were county commissioners and people in the local jurisdictions that wanted to see this happen. So I think I was saying right before I got cut off, just it's important for advocates to partner wherever you can with stakeholders, system stakeholders, policymakers, et cetera, to give them the space to share their support for those policies. And so that was a huge success. It showed that even if the association as a general body, the county's association, was in opposition to passing Raise the Age, that their members were not so. And we were able to, towards the end there, start to make inroads in rural counties as well, not just urban or progressive suburban counties, but get rural counties on board too. And so what that did is shifted the association from being just a blanket obstructionist like they were at the beginning of the Raise the Age campaign several years ago to, having their concerns, but actually being a stronger partner in trying to find a solution, where we got to a point where they were actually hosting meetings to figure out a funding solution. So another strategy that I want to make sure I touched on is making this a legislative priority for legislators. Part of the reason why it took so long to get this passed was just making legislators who were not interested in criminal justice reform for a very long time until this recent wave in the last decade or so, and then are less so interested or educated in the juvenile justice system, help them understand why this policy change was important. Again, another shout out to the Campaign for Youth Justice. They gave us resources to get a poll completed here of voters to show that statewide, with demographic diversity, geographic diversity, et cetera, that there was strong support for passing Raise the Age, and we were able to give that to sitting legislators and candidates for office. To really make this into that Raise the Age a part of the election conversation, specifically in 2018. And so we were able to get legislators, either candidates or those who were actually elected, to make Raise the Age a part of their policy platform with the help of that polling. With also, we worked with the League of Women Voters and other groups that held candidate forums to include Raise the Age as a question during those forums. So once the new session took over, 2019, there were newly elected legislators coming in knowing that they wanted to work on Raise the Age, and reached out to us saying that they wanted to do that. Again, adding to the sense of inevitability that this was going to happen. And the strongest point on that is at the beginning of the 2019 session, our House GOP, both chambers are controlled by the Republicans here, made Raise the Age one of their policy priorities and put out a document saying as much. So again, everyone knew that even when it didn't pass in lame duck of 2018, we knew in January of 2019 that it was going to pass. So
it was a long year though, Jason. It was a long year.
It was a long year and a lot of debate and back and forth about costs. There was a cost study that came out that people tried to delegitimize. We didn't completely agree with all of the findings in it, and we played a strong role as advocates in helping the authors make amendments. I think they made like 3 different drafts. Campaign helped with that as well to get to the final conclusion. But the key point of it is that they, instead of providing one estimate, like you may have seen in other states where they just said Raise the Age would cost $100 million, they gave a range, really highlighting that our system is decentralized and that the counties and the individual juvenile courts really will determine what the increased cost will be, really highlighting out-of-home placement as that huge driver. If you are a county that relies heavily on out-of-home placement, especially expensive, secure ones, you will see a high increased cost. If you're a county that uses a diversion well, who has a robust menu of community-based services, your cost won't be as high. And that actually brought out, again, juvenile court administrators and counties who supported Raise the Age to really highlight that they were one of those counties that were prepared to implement it because they had already put the services in place, made the local jurisdiction reforms to reduce their caseloads overall. Caseloads are declining just naturally anyway, but they've made the efforts to actually be in a place to better absorb 17-year-olds. And they were able to say, hey, we're one of those counties you're talking about that's more primed and ready to do it.
Great.
So,
thank you. Oh, sorry.
Oh, sorry. Just
Nope.
just quickly, yeah. So we Um, momentum really took off in 2019, where we were as advocates trying to catch up to the legislature at a certain point. Once they realized that this was a priority and the thing that they wanted to work on, even when there was conflicts with the governor and there was a halt to any kind of negotiations on anything because of the budget, they made clear that raise age was the next thing that was going to pass. So all the work, we were able to successfully get the law passed in October 2019. Currently, there's a Raise the Age Implementation Task Force meeting. It's coordinated by the Department of Health and Human Services here. I participate on that. Just another important point that advocates should be at the table for these conversations to make sure that they are going, don't get stuck at certain points. And we are on schedule to have it actually implemented next October, a year from now, October 1st, 2021.
Great. Thank you so much, Jason. And I know your work is continuing to make sure that we're shrinking that deep end of the system and getting kids to be served in their communities as frequently as possible. So I appreciate that, and I appreciate all the panelists. We do have another question about Wisconsin. Shonda, thank you for asking that question. I'm gonna actually go back to sharing my screen because there are very, very robust recommendations that come out of all of these states' examples. I'm realizing that we actually didn't write anything in there about the challenge to constitutional amendments, but apparently that does come up quite a bit in your states that are fighting for this. So maybe we need to write a brief about that before we close in December. But just kidding, Brian. But I do want to get to some of the recommendations and the work that's left, because it does tie to Shonda's point that Wisconsin, she states, is the only state left who continues to charge to 17-year-olds as adults. There's actually 3 states, Texas and Georgia, also charge every 17-year-old that comes in contact with law enforcement as adults. And then talking about those very, very lengthy sentences at a 36-year sentence for a 17-year-old, which oftentimes will not be fixed by raise the age legislation because of the many other automatic or required transfer laws. So give me a second, I will respond to that as we have this call to action here. Here we go.
Can I just say something briefly about the Wisconsin question?
Yes, please.
Because I have been talking with Ann McCullough with Youth Justice Milwaukee about this. And I do think, and I've been trying to connect Jason in Michigan. I do think that what Jason was talking about with their campaign in terms of having a big, broad coalition and communicating with all the stakeholders, it's a big lift, particularly in a state like Wisconsin, which, similar to Michigan, is extremely politically polarized, to put it mildly. North Carolina was the same way, extremely politically polarized. So it's not going to be like an overnight thing, but building a big coalition, and I think Jason had a lot of really good sort of examples of how they were sort of ratcheted it up over the years, and eventually had this sort of bipartisan sense of inevitability. So I do think that's what it's going to take in Wisconsin is a big, broad coalition. So I do think it would be good to bring together a group of people who are interested in this and have Jason come over, if you can come over these days, but have Jason talk through sort of what they did in Michigan and sort of think about how that could apply to Wisconsin.
Yeah, and you also have Illinois right next door too that
Yes.
also did this and then passed subsequent
Yeah.
transfer laws that were retroactive and very, very powerful. So, so as Brian just alluded to, we're really close. This is the call to action for all of the young people who remain in the adult system. We need states to finish raising the age. That is Georgia, Texas, and Wisconsin. It is not deep end reform, no matter how much they want to say that they don't have beds. That is not relevant to raise the age. It is probation reform, it is diversion reform, it is front end reform. It does not increase cost, confinement, or crime anywhere near what you will hear when you are fighting to enact the law. We also call on the field to target the 9 states that automatically transfer 200 or more youth a year. Again, Brian went over those 9 states. There is no reason for numbers to be that high, even though Florida got rid of their statutory exclusion, they're still, in the high hundreds of children every year sent to adult court. Maryland is 3rd in the country. I want to say that again. Maryland is 3rd in the country in the number of young people that originate in adult court. That is unacceptable. The third thing is to remove youth from adult facilities by 2021. JJDPA requires this by 2021. We are in a big push to try to get states to pass their laws in 2021 and have them fully implemented by the time the next JJDPA reauthorization happens in 2023. Shonda, this is a point I want you to listen to. There is a movement around second look legislation and repealing mandatory minimum sentences. Brian does a good job of outlining that in the report. I do encourage people to look at that because there are too many children who got significant sentences that do not qualify as juvenile life without parole. The second look legislation gives people a second chance to get their sentences reviewed, oftentimes in front of a judge. And DC, under that law, just released its 50th young person who's now grown under that second look legislation. So it can have very significant impact. So I would call on folks to look at that and to look at models. We didn't talk a lot about the narrative work that the campaign has done, but we have seen this change due great part into a lot of education with journalists, with media, and with all of you who have raised up stories saying that's not what happened. We need to end the narrative around this myth of a violent versus a nonviolent child. That is not the conversation that anyone should be having. That is not how we should determine who is going to the adult court and what services children get. So it drives racial disparities, it is ineffective, and we have to remember that children are much more likely to be victims of violent crime than ever to perpetrate, violent crime. The sixth thing we need to all be fighting for is to invest in those community-based and community-supported alternatives, right? So we can continue to tinker with system reforms, but again, I'm going to point to California. That money a lot of times never gets to the hands of the communities that are actually doing some of the most important work. And we need the community-based organizations to get the money. We've seen in COVID, I've been on many calls with judges, with court administrators, with probation officers who said that community-based supports are what's getting those services, even during COVID, to families in need. So we need to keep asking for this. There's another big part in the reform. We heard several people talking about the impact of COVID and the racial justice movement around policing reform. Both have had significant impacts on youth decarceration. They can both be leveraged much further than what they currently are. As Brian said, we still have half the number of children that are waived to adult court are there for non-person crimes, right? And so we are still transferring way too many kids. None of those kids should be going up at all. They need appropriate supports in their communities. And we should be using COVID and policing reform as calls to do just that. And then finally, and I know there's been a lot of talk about this, Illinois raises this frequently. The United States still needs to ratify the UN Convention on the Rights of the Child, which calls for 18 to be the age at which any child is ever considered an adult in the criminal justice system. And I do want to give a shout out to Brett's point about raising that minimum age. While the UN calls on that minimum age to be 14, in the United States, we have very few states who even set it at that 11 or younger age. And I think that that is another way to get very young children out of a system that they have no business being in the first place. So as I said at the beginning of this, and we can take a couple questions for our panelists as we're getting ready to wrap down, but this is the work that needs to happen state by state. The information I feel like is largely already out in the field. We have plenty of models of which we've showcased here today, but plenty more. 24 states changed their laws in the past 3 years. So pick a state that matches your needs, and I know we can connect you with an advocate and a young person or a family member to tell you how they got there. So I want to thank the panelists and open up the floor again to anyone who might have questions. Got another question from Wisconsin. So we see you, Wisconsin. We hear you. We've got lots of folks around you that can support you. And I would just say, in terms of Wisconsin, we really just need to figure out where you guys want to start with your reforms, because your minimum age of transfer there is incredibly young. You've had 3 children under the age of 12 and younger sentenced to adult time there recently. And so there's a lot of work that can be done in Wisconsin. If Raise the Age is not the place to start, there's plenty of other options that you guys have in the toolbox here. Any other questions before we bid everyone a nice afternoon and thank our panelists and Brian for getting this report out? Any last words from our panelists? Are we all good, folks?
Thank you for having me on this call, and thank you for this opportunity to be able to voice myself all the way from Los Angeles. And thank you, Zoom, for making this possible.
Thank
Also,
you, Oscar.
we'll do one more thing to Wisconsin. Just know that you guys have California to back you up, and you guys have me to back you guys up. It's very unfortunate that 12-year-olds are getting tried as adults. That's enraging. That's sad. But yeah, yeah. Well, thank you once again for having me.
Yeah. Thank you, Oscar.
I do think there were like 2 or 3 people from Wisconsin in the chat, so we should definitely try to connect all those people together if they're not already connected. Thank you, everybody, for all the work you're doing and all the work you will continue to do in 2021 and beyond.
Elizabeth, I think I saw you ready.
Yeah, I was just going to say thank you for this report, Brian and Marcy and everybody else who worked on it. It's really great, and thank you for all your help over the years, and we're going to really miss you.
Yeah.
Very sad that you guys are closing doors, but your legacy will be great because you've been active in so many different places and really played such an important support role. I can speak from California, but I know you are in so many places, and we really, really appreciated it. And so thank you for everything.
Thank you. Thank you. And that's actually a perfect segue, because I do want folks to know that the sentencing project, I will be moving there next year for a year to work, to bring this work to them, to make sure that they are up to speed on all of the research and tools that we have, so that they can continue to be a resource. They won't, I don't think, run campaigns in the same way that we do, but they will certainly continue to be a wonderful and reliable resource for the field. So I want to thank the Sentencing Project for allowing us to do that. All right. All right, everyone. Have a wonderful day. Thank you all so much. And we appreciate you all for all of your hard work on the ground. Thank you, state partners.
Bye, everybody.
Bye, everybody.